Joining us this afternoon, and we welcome you to the first webinar of our ongoing webinar series. As many of you know, we have scheduled 4 webinars so far. Our next webinar will be on June 27th, followed by a webinar on August 22nd and September 26th. The webinar topics will change based on what's kind of hot in the area, and based on your feedback and questions following this webinar, we'll address those issues as well. Today, joining us is Patrick Duty. Pat is a partner in the firm's intellectual property group and is also the head of the USPTO litigation team. But just a quick administrative detail, we wanted to let you know that all participants are automatically muted upon entry to the webinar. If you do have any questions, please feel free to let us know. You can do that by clicking on the chat button at the lower right-hand corner of the WebEx tool. Also, at the end of the program, if you have any questions, comments, or suggestions for additional programming, please be sure to email today's speaker, Patrick Duty. His email address is provided in the PowerPoint. Also, again, this is Megan. My contact information is available in the invitation, and we'd welcome the opportunity to hear more from you. So without further ado, I'm going to pass it over to Pat.
Great. Thank you, Megan, and thank everybody for joining today. Really appreciate it. Like Megan said, we're going to try to do these on a periodic basis, not so much in the summer because most people are probably out on vacation. But we have 4 of these planned. The first one, what I wanted to do, and I kind of want to follow this format, I think it might be a good one for people, is to have kind of a main topic that we'll talk about, and then at the end, I will just fill in with some facts and statistics. We've been following all of the IPRs and CBMs. I just call them post-grant proceedings, and that covers all of them, the covered business methods, post-grant review, and inter-parties review. And we file all of them that have been filed, decisions on granting trial. There's only been 1 trial that I know of. Maybe there's been another, but the first trial was April 17th. And so we're trying to keep up with everything that's been going on, and we compile some statistics, and of course those will change over time, and the more data we have, the more reliable those statistics will be. And so that's how I intend on ending these. So the next one that we do, we'll have another topic that hopefully will be of interest to everyone. And if there are a lot of questions on this, which I think there will be, maybe we'll be able to answer them in more detail. So quick overview on what I want to talk about today. As many of you know, the Patent Trial and Appeal Board has already been working on these since September 16th of 2012, and there have been over 300 of these post-grant proceedings filed. Not so many covered business methods. Most of them have been inter-parties reviews. And what the PTAB has been doing is they're granting trials, sort of like getting you into the inter-parties re-exam. So they've been granting trials on a fair number of these cases, but when they do so, they grant them on far fewer grounds than are proposed in the petition. And that's what at least in my experience, is quite unlike the inter-parties re-exam, where you could propose 40, 50 grounds of rejection, and typically your first office action, the examiner will just repeat what the requester put in their request. Not so at the PTAB. They're actually paying very close attention, considering all the arguments, and it really, at least from what I can tell from the statistics, doesn't seem to matter whether the patent owner even files a preliminary response. The PTAB has actually denied a petition, even though the patent owner never even filed a patent owner preliminary response. So the main topic today, though, is going to cover what is the estoppel effect of the grounds on which the PTAB has denied the petition. So if the petition proposes 10 grounds and then the PTAB says we're only going to grant trial on 2 grounds, what happens to those other 8? And is there the estoppel effect? And then I plan on finishing with some facts and statistics. So like I said, PTAB's granting trials on far fewer grounds than are proposed. In fact, what I've seen, and this is fairly consistent, I started this about 4 months ago, and it's been fairly consistent that it's less than 30% of the grounds that are proposed are being granted for trial. So that's so if you file 10 proposed grounds in your petition, there's a pretty good chance that you're only going to get about 3 in trial. And in many cases, the PTAB will decide on which grounds to proceed to trial. So they may deny some grounds as failing to meet the threshold standard. So there's a threshold standard for both inter-parties review and post-grant review. And post-grant review covers the covered business method transitional program because that's a post-grant review proceeding. The statute has a series of statutes in the 310 series covers the inter-parties review. The 320 series covers the post-grant review, and they closely parallel one another. Very similar language in both. So the threshold standard for inter-parties is a reasonable likelihood that the petitioner would prevail with respect to at least one claim, and the threshold for post-grant is it's more likely than not that at least one challenge claim is unpatentable. So the PTAB is denying some grounds because you don't even meet that threshold. But what they're also doing is, let's say there's 10 proposed grounds. The PTAB says we're going to go forward with 3. 4 of them we're going to deny because you failed to meet the threshold. And then the other 3 we're going to deny because, in the PTAB's opinion, they're either cumulative or redundant to the grounds on which the trial is granted. And so that raises a whole lot of questions for a lot of people, and hopefully for you. And again, any questions that you have, please either send an email or a note during this WebEx, or email me afterwards. I'm happy to answer any questions that you have. So what's the problem with the PTAB deciding which grounds to proceed? For one, it's much unlike proceeding in a district court where you get to decide what you think is the best grounds. You know, the PTAB, you might propose 10 grounds, and you might think grounds 1 and 2 are the best. The PTAB might come back and say, well, we think 2 and 3 are the best, and 1 or 2 are denied as merely cumulative. Now you, as the petitioner, sort of feel like, well, I don't get to put my best foot forward. In district court, you're typically given the opportunity. The court doesn't just say, no, you can't pursue those grounds. They might ask you to limit, but you at least get to limit. So far what's happening is the PTAB is basically deciding this for you. The other issue is, do they even have the authority to do this because you've met the threshold? So if the PTAB denies a ground as cumulative or redundant, they basically have said, look, you've satisfied the threshold in the statute, but we're still not going to let you go to trial because we think it's cumulative or redundant. And there's been a lot of questions raised as to whether the board even has that authority. And then finally, what happens on those cumulative grounds? What happens if the PTAB says grounds 2 and 3 are the best and 1 and 2 are denied as cumulative, but then, for example, the patent holder is able to convince the board that grounds 2 and 3 really weren't all that great, and the board is going to issue a patent? Do they go back, kind of like an election of species, and go back and consider the cumulative or redundant grounds? I don't think so. I don't know yet, but I doubt that they will, since they denied the ground, so there's a pretty good chance they won't. Another question to consider is, if you're the petitioner, should you file another petition on those cumulative or redundant grounds? And we'll talk about that in more detail a little bit later. So far, the PTAB says it does have the authority to deny trial based on this cumulative or redundant grounds. And what's happened is some petitioners have been filing requests for rehearing that challenges the decision. As many of you know, the decision, this is just like the reexamination as well, the decision by the board to grant or deny trial is not appealable. So it's final. Your only avenue is to, in the inter-parties re-exam context, you could file a petition. In the post-grant review and inter-parties review context, you file a request for rehearing, where you ask the board to reconsider its decision. In 2 cases in which the petitioners filed requests for rehearing on grounds that were denied because they were cumulative, the PTAB has decided against the petitioner. The first is the covered business method 2012-7, and the board relied on rules 42.1b and 42.208a, which say that these rules authorize the board to proceed on all or some of the challenged claims or grounds of unpatentability to ensure a just, speedy, and inexpensive trial. The boards also cited some public comments on the published rules and noted that there was one comment that suggested that trial proceed on all grounds, but they did not adopt that comment. And the board cited this Federal Register. I put the citation here, 77 Fed Red 48680. And I've read through it, and I don't really think that supports the board's position. But in any event, I think that the rules 42.1b and 42.208 do support the board. In the other request for rehearing that was denied, that's in IPR 2013 number 14. They relied again on the same rules, although this is the corollary to the covered business method or post-grant review. It's the inter partes rule, and that's 42.108b. And that's basically they're construed to secure the just, speedy, and inexpensive resolution of every proceeding. So what they're trying to do is narrow down the grounds, and so they can issue their final written decision within 1 year as required by the statute. The PTAB has also granted some requests for rehearing. So in some instances, they've denied grounds, and they've even denied them on the failure to meet the threshold, and on rehearing, they've thought it over and decided, well, maybe they did meet the threshold. So I don't think it hurts, and I think it benefits you for a number of reasons that we'll talk about later, to file a request for rehearing. If you file a petition and you find yourself in this position where you've been denied trial on some of the grounds that you request in your petition. I am not aware of any PTAB decision yet that has allowed a request for rehearing and granted it on the grounds, though, that the petition was denied on cumulative or redundant grounds. The 2 or 3 that I looked at the other day were both, all of them were denied on the grounds of failure to meet the threshold, and then on rehearing they decided against it and granted the trial on those. So finally, the request, though, does preserve your right to argue later that estoppel cannot apply because the ground could not have reasonably been raised in the trial. You tried everything you could. You used every possible avenue to get this into the trial, and the board and the patent office said no. So I think you have a pretty good argument that you could say, well, this ground could not have reasonably been raised. The board denied it. And importantly, you'll not have a final written decision on the grounds that you're denied. So this leads us to the major issue of today, which is the petitioner estopped on grounds that were denied? The estoppel provisions in the statute, 315E2 and 325E2 for inter partes and post-grant review, you're estopped in litigation from asserting a claim is invalid on any ground that was raised or reasonably could have been raised. So what about grounds that are raised in a petition but are denied? So there's 2 of them, right? You've got denied for failure to meet the threshold, and then denied because they're cumulative to grounds on which trial is granted. And I'm going to talk about 2 different types of estoppel. One is the statutory estoppel that I just alluded to, the 315E2 and 325E2. But the other is, as a practical matter, are you estopped? And I think that's a fairly straightforward argument, but we'll get into that in a little bit. So is there statutory estoppel? I included in here the actual language from the statute, and it's pretty similar. 315E2 and 325E2 contain very similar language. Originally they didn't, but they do now, and it has to be a petitioner in an inter partes review, or it could be post-grant review, of a claim in a patent under this chapter that results in a final written decision, or the real party in interest or privy may not assert in a civil action or in a proceeding before the ITC that the claim is invalid on any ground that the petitioner raised or reasonably could have raised. There is a little bit of debate about the reasonably could have been raised estoppel in the post-grant review provision because it wasn't in the version that the Senate adopted, and when the House adopted its version, the reasonably could have been raised popped in. And there's been a couple of legal articles on this. There's been a lot of blog posts and people discussing on whether or not this was a mistake by the House when they implemented H.R. 1249, when they stuck in reasonably could have been raised. But it's in there, it's in the statute, and it was signed into law, so I think we have to live with it at this point. So, is there statutory estoppel? If the ground was denied, you're obviously not going to get a final written decision. So that would kind of tell you that probably not. There shouldn't be statutory estoppel. The ground also could not have been raised. Why not? Well, because it was denied. We filed a request for rehearing, and it was denied again. But to allow you to file a petition, argue 10 grounds of unpatentability, have 6 of them denied, and then be able to go back into district court when you don't prevail at the PTO trial and argue those 6 that have been denied would appear to be somewhat inconsistent with the intent of the estoppel provision of the statute. And there's a lot of legislative history on this, that the intent was to avoid harassment of patentees by permitting multiple validity challenges in different jurisdictions and different forums. So to me, it's still an open question. That's why the next slide I have maybe no statutory estoppel. If you read the legislative history, some of it supports the view that estoppel should not apply to denied grounds. Part of the history includes comments by Senator Kyle on March 8, 2011, and I quote a bunch of them in here. In one point, he says, look, the PTO doesn't even apply its own estoppel, and this is with respect to inter-parties re-exam, to an issue raised in a request for inter-parties re-exam if the request was not granted with respect to that issue. And this pertains to the first paragraph of 315 and 325, which is proceedings before the Patent Office. There's 2 different estoppels. There's the estoppel at the Patent Office and estoppel in district court. Estoppel at the Patent Office is, you file an IPR on claims 1 through 10 and you lose. You can't file another IPR on claims 1 through 10 on any grounds that were raised or reasonably could have been raised. But it appears that the Patent Office, at least in the reexamination context, was permitting subsequent inter-parties reexaminations on grounds that were denied, for which there was no substantial new question of patentability. So if it's similar to inter-parties reexam, which inter-parties review is supposed to be, then that would support an argument that estoppel should not apply. However, as you might expect, there's also parts of the legislative history that support the view that estoppel should apply. Senator Kyle continued. The next sentence says, look, the office could nevertheless refuse a subsequent request for ex parte reexamination with respect to such an issue, even if it raises a substantial new question of patentability, because the issue previously was presented to the office in the petition for inter-parties or post-grant review. So even though they may allow it, they also might not. Page before the comments I just quoted, Senator Kyle also said that the current law is amenable to the interpretation that litigants are stopped from raising any issue that it would have been physically possible to raise in the inter-parties re-exam. This is where he's talking about, look, back when they had the reasonably could have or could have raised argument, he was saying, look, the could have raised should only apply to this scorched earth search around the world, and it doesn't make sense, and therefore we should include the word reasonable in there. So that ensures that the could have raised estoppel extends only to prior art to which a skilled searcher conducting a diligent search reasonably could have expected to discover. So what he's saying here is, if you, in a scorched earth search, find new prior art, then you should not be estopped. So we're still kind of left with, is there estoppel or isn't there? And I don't really know, and that's why I would love to hear anybody's comments, questions, any arguments you might have to support it one way or the other. I'd be interested in reading them, because it doesn't appear totally clear whether the statutory estoppel applies. If it's similar to res judicata, which some have argued because it has many of the same elements as res judicata, even though it's not another court proceeding, it's an administrative proceeding, then estoppel probably should apply to all grounds raised or reasonably could have raised. But there was a recent Federal Circuit decision, Belkin International v. Capos, which was decided in October of last year, where the estoppel argument was made, and this is in the context of an inter-parties re-exam. In that case, there was an inter-parties re-examination request. Some of the grounds for unpatentability were granted, and some were denied. Belkin did not file a petition. Granted, remember, they can't appeal that decision just like you can in an inter-parties review, but they never filed a petition, which is similar to the request for rehearing. And the court made a lot of hay about that. So that's why I would recommend filing a request for rehearing if you're the petitioner. But they also made the argument that, well, what about the estoppel provision? If they denied the grounds for reexamination, why should I be stopped from arguing it later? And so in dicta, which is not the law, but the Federal Circuit did say the question whether or not the estoppel statute works to preclude citation of a piece of prior art that a requester cited, but that the director determined did not raise a substantial new question of patentability is not before us. So they're telling you right here, this isn't before us, but then they go on to say, suffice it to say here that the courts have the final say on unpatentability of claims, not the PTO. The director's determination that an issue does not raise a substantial new question is not a final determination of validity or patentability. And so I think that comes back to the statutory language of a final written decision. There's no final written decision on a ground that was denied. So I think this would probably support the argument that no estoppel applies because there's no final written decision with respect to that ground. So I talked about statutory estoppel. I want to talk for a minute about practical estoppel. And practical estoppel is what you might think it would be. You know, maybe you're not statutorily estopped from arguing it, but as a practical matter, I think it's going to be tough, especially for grounds that were denied due to failure to meet the threshold, right? Because if you think about it, the threshold of the Patent Office is lower than the threshold of the district court. And if you can't satisfy that lower threshold of the PTO before patent experts, and based on the broadest reasonable claim construction, which is different than in the district court, how can you possibly satisfy the clear and convincing threshold in the district court? So as a practical matter, it's going to be a very hard argument to make that you shouldn't be estopped due to failure to meet the threshold. But what about the grounds denied because they consider them cumulative to or redundant? I mean, here you have, I met the threshold, the board considered them cumulative to or redundant, but we disagreed with the board. We filed our request for rehearing, they still denied it, but we still think they're wrong, and we think these are better arguments, and that's what they should have gone on, but they denied us, so we couldn't have raised them, and we don't have a final written decision. We don't really know what's going to happen. I think we're going to have to wait to see how district courts apply this, and probably for a Federal Circuit decision right on this issue, which I would expect to happen, you know, in the next 4 or 5 years. But in the interim, what are we going to do? Some of the strategies for filing your petitions. The PTO, which is interesting, the PTO's stated goal for denying grounds as redundant or cumulative are they want to ensure a just, speedy, and inexpensive resolution. But if they're denied as cumulative and the petitioner is not estopped, this encourages you to file as many, right? Because if you only file a petition on 4 grounds, but you could have on 10, then you're going to be estopped on those other 6. If you file on all 10 and you're denied on those 6 and not those 4, well, maybe you won't be estopped. We don't really know. But this seems to kind of militate against the board's rationale for denying grounds as cumulative. I think they're actually encouraging you to file even more grounds in your petition and request for rehearing, and perhaps even filing additional petitions for inter-parties review or post-grant review. So, you know, if the estoppel does apply, then I think you probably would be wise to file a subsequent petition, and that obviously is not inexpensive. So once again, it kind of militates against the board's rationale for denying these grounds. And of course, you can always file multiple petitions and then request joinder and be in the same position you would have been in if you filed them all at the same time. presuming the board grants your motion for joinder. So what do we do now? I think it's useful to file petitions with multiple grounds. I've heard arguments one way or the other that you should narrow your grounds, but I think you run the risk that if you only file on 4 grounds and they grant on all 4, but you could have filed on 10, you're going to be estopped on those 6 because of the reasonably could have raised portion of the estoppel provision in 315E and 325E. So I think you should file with multiple grounds. It preserves your right to argue there's no estoppel later by filing a request for rehearing. And as an alternative, like I said earlier, you can file multiple petitions, but of course, that's not inexpensive. All right, so with that, I wanted to go on to some interesting facts and statistics about some of the IPRs and CBMs that have been filed to date. Like I said earlier, the first trial was held on April 17th. And that was in this Covered Business Method 2012 first. This is the first one. No surprise to many, the trial was much more like an oral argument than a trial. There were no live witnesses, few exhibits, consistent with interference practice, which is, you don't have your live witnesses, you're not cross-examining people on the trial, on the stand. It was short. I think it was only like an hour and a half, maybe. I can't remember how much time was accorded to each side. It could have been 40 minutes or 60 minutes. It escapes me. I can't remember what it was, but it's relatively short, so it's much like an oral argument. Another interesting thing to keep in mind when you're handling either a post-grant review, a covered business method, or inter-parties review is that the board can modify some of the rules. There's authority in at least 37 CFR 42.5 to modify some of the times. So your time for responding to certain motions could be modified in some of the board's decisions, and they don't show up in the rules. For example, the time to oppose a motion for pro hoc vice emission is 1 week from the filing of the motion. And that is set by order in a IPR 2013 Matter 10, which dated October 15th. So that order actually granted people the authority to file a motion for pro hoc vice emission at any time after 21 days from the filing date that the board said they gave the filing date. So the board will issue a paper shortly after the petition is filed, granting the filing date. So 21 days from that period, which is typically when the patent owner has to file their mandatory notices, that's when you can file these. And if you're going to oppose it, you have to file your opposition within 1 week. There's only been one that I'm aware of where they granted an opposition for pro hoc vice emission. There's actually a section on the PTO website. I provide the site for it here, called Representative Orders and Opinions. I don't know how often they update it. I think the most recent order or opinion on that is April 24th, so it's a month ago. Nothing's been uploaded since then. What I would expect to see from the board, and this is similar to interference practice, is the standing order. If you've ever been involved in an interference, you usually get the standing order, which varies from what the actual rules are. So actually going and reading the rules, which you think would be the wise thing to do, might not be the best thing to do, because the board will issue a standing order that says, okay, this is how these proceedings are going to go forward. So I would expect to see something like that probably in the next year or so. It's going to take a little while, but as they work their way through these, that's what you'll see. But for now, you've got to look at the papers, and many times the board, the PTAB, will refer to other orders that are available on this particular section of the PTO website that you have to go look at and see what the times are, or whatever the decision was in that would apply to your case as well. So here's some interesting statistics. As of today, at least from what I checked, there's 312 IPRs filed since September of 2012 and 24 CBMs. So based on the proposed rules and the rules that that the PTO set out, I think it was in August of 2012. They were anticipating, I think, 460 or so IPRs, so it looks like the IPRs are kind of on track for what they anticipated. CBMs, they anticipated a lot more. So there's far fewer CBMs than anticipated. That might change, as some of you may know. There was a proposed piece of legislation. It's probably the shortest bill ever introduced in Congress, at least certainly the past 2 or 3. It's 2 sentences long, and what the proposal is to change the covered business method, which now only covers financial services related business method patents, to include all business method patents. So I haven't really been following that since that was proposed. I don't know if they've even had any kind of debate on it, but there was a proposal a few weeks ago to greatly broaden the covered business method transition program to cover all business methods, not just financial services. So the statistics that we've compiled, I think they're about a week or 2 old. So as of last week, 88 decisions have been rendered to grant or deny trial, and out of those, 80 have been granted, so that's about 91%. Right around where the inter-parties re-exam was. I think inter-parties re-exam, even after they changed the standard between September 16, 2011 to September 16, 2012, they changed the standard. It was supposedly going to be a heightened standard, and I think from what I remember seeing, statistics were about 93 to 94% were being granted. So it's a little bit lower, but again, I don't think we have enough data points that make these overly meaningful, other than to show you some trends. But like I said earlier too, only 29% of the proposed grounds. So they're granting trial, but on 1/3 of the grounds that are being proposed. 8 have been denied, so that's about a 9% denial. 11 have been granted on all proposed grounds, and I think the most I've seen is about 10. So they've granted trial on 10 proposed grounds. For the ones that have been granted on all proposed grounds, those are mostly 3 or 4 or 5 that are proposed in the petition, and then the PTAB grants them on all of them. Another interesting statistic is that 89% of IPRs and CBMs filed to date have been related to litigation or other IPRs and CBMs. So there's a related proceeding, mostly litigation. So it appears to be that the intent of Congress in enacting these, which was to have the Patent Office be the avenue in which you contest validity as opposed to in a district court, may be coming to fruition, because most of these are a corollary or an adjunct to a litigation matter. And then 6 that have been filed to date have been terminated due to settlement. So oftentimes the parties settle, and as a result, the parties can file a request to terminate the proceedings. And for the most part, the board has done so. I haven't seen one yet where the parties, or one of the parties drops out. The board does have the authority to go forward. I know they do so in inter-parties re-examinations. Even though the third-party requester might drop out, the Patent Office would still proceed. But in these, I think most people expect the board, and from what I heard prior to these trials coming into effect, I think it was Judge Tierney was going around the country giving a lot of lectures, and he said for the most part, if the parties settle, the board's not going to continue on with the case. And there's actually a statutory provision that allows you to file a document to terminate the proceedings. Okay, so with that, here's my email address. Please feel free to email me any questions that you might have. I'm happy to answer any of them, take plenty of time to answer them, no problem at all. And most importantly, I wanted this really to be a topic of discussion as opposed to, here's the definitive answer, because I don't think there is one. But if others have a different point of view, I'm always interested in hearing what that is. I would love to hear from people what they think about the estoppel effect for grounds that were denied in your petitions. And with that, I'm just looking to see if there are any questions that have been posed, and I don't see any. So, thanks again for joining us. I hope this was somewhat informative, and I hope people do have questions and comments, and you email me with those. And like Megan said, we plan on having these periodically. The next one's scheduled for June 27th, then after that August 22nd, and then after that September 26th. And we'll have a different topic each time. So thanks again. Have a good day.